for now to your computer. I'm working with Lester and Tommy on how to deal with it afterward.
Okay, we're good to go.
Okay, I'm going to start. Hello and welcome. I'm so glad that you could join us today for our first statewide housing Zoom training. This is our first Zoom training, so please excuse any issues with the tech. This is a learning experience for us. Today we will be providing information that tenants need to know about eviction. This information only applies to tenants in Georgia. Because of the COVID-19 pandemic, our country is facing an eviction crisis. In Georgia, it is estimated that over 500,000 households are at risk for eviction, having missed a recent rental payment. By the end of the year, there could be almost 400,000 households evicted in our state. We must work together to address this crisis. The Georgia Legal Services Program has a long history of representing tenants in subsidized housing. Through our Eviction Prevention Project, GLSP also focuses on the legal needs of tenants renting in private, non-government subsidized housing. Today we are sharing legal information on the eviction process in Georgia. We hope that this will help agencies advise tenants through the process and help tenants navigate the eviction process. If you have questions during the presentation, please type your question into the chat box below, and we will do our best to answer your questions. We, of course, cannot provide legal advice through chat, but we can provide basic information and referrals. Remember that unless you select to make your chat private, all participants can see the question you ask and our answers. Also, if you would please mute your video and your sound and keep yourself muted during the presentation, that would be very helpful. Now, I will turn our presentation over to Elizabeth Main, the Eviction Prevention Project attorney in the Piedmont office of Georgia Legal Services, which serves the area surrounding Metro Atlanta, and to Colleen Barclay, our GLSP's Eviction Prevention Project attorney in the Augusta office of Georgia Legal Services. And Elizabeth, I believe you will be starting today. Thank you.
Yes, I will. So hi, everyone. As Susan said, please keep yourself on mute and your video turned off. We are recording today. We would really rather not record anyone who's on the call. And we will provide our contact information. So if you need specific legal information, please wait till the end, and we'll have our number there. And you can also find us on our website if you need specific legal advice about your exact situation. So basically, I'm going to start off talking about specific issues that have come up during the COVID-19 crisis. This has been difficult for all tenants because the protections available have been coming from a number of different sources in the government, and they've been constantly changing. Things expire, new things go into place. So we're just going to try here to clarify exactly what protections are available at this point in time. And I want to just also specify, since we are recording, that this presentation is happening on August 21st. If you're listening to this via some recorded site, it's on social media or something like that, please keep in mind this information may at some point go out of date. Again, things keep changing. So if you have questions about your situation, you're listening to this after the 21st, please contact our organization so we can give you the most up-to-date information. All right, so I'm going to start off with courthouse responses to COVID-19. So this is coming from the judicial branch. So starting in March, the Georgia judicial system took steps to prevent COVID-19 from being spread through the courthouses. So again, this is specifically through orders from the Georgia Supreme Court. This isn't coming from the federal government. And these steps were done specifically to protect people from being exposed to COVID-19 by being forced to go into the courthouses. So it wasn't a step to necessarily make a statement on whether or not people should be able to be evicted by the courts. It was really just to protect people from having to go to the courthouses. These judicial emergency orders that have been issued from the Georgia Supreme Court prevented in-person hearings of eviction cases between mid-March and mid-June approximately. So many decisions were left to be made at the county level by these judicial emergency orders. Eviction cases in some counties could be filed. Some counties, they were even serving the eviction cases on tenants. In some counties, you couldn't even file. And in some cases, they just, they accepted the filings but weren't serving them, and they just backed up that way. Essentially, though, if a case was filed during that time, it was delayed until after the judicial emergency orders, again, permitted people to file answers and have hearings. That time has passed. That happened in mid-June. So at this point, those cases are being heard in all counties in Georgia. The current emergency order, there is still a judicial emergency order in place, but it is not as strict as the ones that were issued at the beginning of the epidemic. The current emergency order allows cases to be heard in person, but the Supreme Court of Georgia is very clear that those hearings have to be consistent with public health guidance, and they can't impose undue burdens on participants. This doesn't mean that an undue burden would be like if you don't have anywhere to go or you've lost your job because of COVID-19. That's not what it means by undue burden. Essentially, the court is concerned about people being forced to be put in an unsafe situation by having to go to court with a lot of other people and be exposed to that. So your local courthouse's COVID-19 operating guidelines are going to be posted online. And this is your county courthouses. All county courthouses are required to have these guidelines posted. That was in the judicial order as well. In all counties, social distancing guidelines do have to be observed. I'm sure you've heard about that, 6 feet apart. Masks need to be worn in the courthouses, and also most courthouses are checking temperatures at the door. All of those guidelines are very strict. If you show up at court without a mask, sometimes most of the times you will not be let in unless you have some kind of medical paperwork with you showing that you don't need to wear a mask. And if you just don't have one and you showed up without one right on a hearing date, that could result in your missing your hearing and having a judgment against you. So we do advise you to please remember to show up with a mask and follow the guidelines. Many counties offer options for remote hearings. If you're concerned, if you're at risk, particularly of COVID-19, for some other reason you're not comfortable going to court, many counties will offer options for remote hearings. Not all, and they will not automatically grant you one. So you need to request it. Contact your local clerk of magistrate court. And again, unfortunately, we can't give you advice on how to do this for every county because every county is different. So contact your local clerk of magistrate court, and they will be able to give you more information about how to do that, and if that's available in your county. What to know about remote hearings, and obviously hearings in general. Make sure everything is in place for your hearing over 24 hours before the hearing. So if you have a remote hearing that you're going to be going to, don't try to gather your evidence and get everything together and find a computer to use the night before the hearing. If you have any problems with that and you're not able to show up at your hearing and you just miss it, there is no guarantee that the court will be willing to reset it if you've missed your hearing. You may just have missed it, and that may be the end of it. If you're not using a computer set up at the courthouse, which some courthouses have and some don't, be sure you've checked your computer's video and audio before the time of the hearing. Do not turn it on 15 minutes before and then find out that nobody can hear what you're saying and you can't check into Zoom or whatever their software is that they're using. Check with your local clerk of court in advance to find out if you need to submit evidence to the court prior to the hearing date. This could be, and you want to think about this ahead of time, rent receipts, police reports, video or photos showing the condition of the property, written communications. If you have people that you want to speak on your behalf as witnesses, make sure you've organized all of that beforehand and let the clerk of court know how to reach your witnesses, and if they need copies of these documents, make sure that they have them. And again, you'll want to call the clerk of magistrate court in your county to ask how to do this. It is county by county specific. Do not send also, if you need to submit your evidence, do not submit the only copy that you have. For example, you want the judge to be able to see this evidence. Do not, if you need to give a paper copy to the court, please don't give your only copy. We've had that happen before, and then maybe the clerk of court mislaid things, which shouldn't happen but does happen sometimes. Or if something was mailed and it got lost in the mail, and if you don't have it anymore and nobody has it, then it's gone. So please be careful about that. If your courthouse is not following their posted guidelines or is compelling you to attend a remote hearing and you don't have any way to attend it, you don't have the technology to do that, contact an attorney. Again, we'll have our information at the end of this presentation so that you can reach out to us if you're having this issue. Social distancing guidelines should be observed. People should be wearing masks. There shouldn't be mass calendar calls happening where everyone is sitting packed in together in a small courtroom. If that's happening, please let us know. Next, we're going to talk about the legislative branch. So the Georgia legislature has not issued any legislation dealing with eviction protections at this point in time. So this is talking only about the federal Congress. They did pass a piece of legislation called the CARES Act. This was passed months ago. It is now technically expired, but some of the protections will still apply in very specific situations. So I'm going to try to clarify exactly what that is. So the CARES Act protects, it offers limited protections to tenants who are in subsidized housing, tenants who have a housing voucher, tenants in properties with mortgages that are backed by Freddie Mac or Fannie Mae, and that's the federal mortgage lenders. This does not offer protections for everybody in rental housing. It doesn't offer protections for people who are in private rental housing, or you're just renting from a private landlord, not from the government, not through a housing authority. And it only offers limited protections. Specifically, before July 25th, landlords could not file evictions against protected tenants for non-payment of rent. This still applies to any rent that was owed before July 25th. If it would have been due before then, you still need to be given a 30-day notice. And in addition, you can't be charged late fees for rent that was due between March 27th and July 25th. After July 25th, the period that we're in right now, people can still be evicted under the CARES Act, but they need to be given 30-day notice. This is only if the eviction is for non-payment of rent and includes rent that was due before July 25th. So if you've paid up through the end of July and then starting August 1st you weren't able to pay rent, these CARES Act protections would not apply to you. If, however, your landlord is filing for eviction saying you didn't pay rent from July 1st through the end of August, these protections might apply to you. And I'm going to go over really quick how you can know if you're covered by the CARES Act, because this can sometimes be tricky as well. You're most likely covered if your rent is adjusted based on your income, if you have to do some kind of an annual income recertification or like an annual inspection of your housing to make sure that it is in good enough condition, if you deal with a public housing authority, if you don't pay market rate rent, if you're paying something less than what the property would regularly be rented for, you would be covered by the CARES Act. There are two websites here, and again, this will be recorded, so if you're not able to look to copy these down now, that's fine. There's a website for Freddie Mac, there's a website for Fannie Mae. Check them both. Don't just check one of them, because these are two separate federal organizations. You want to look at both. You can put in your property address on these websites, and it will tell you if you may be protected under the CARES Act. Also, in response to the CARES Act, there's a new magistrate court rule in place. The Georgia Uniform Magistrate Court rules are basically the rules that all magistrate courts across the state have to follow. This rule says that all landlords have to file an affidavit stating that their property is not covered under the CARES Act in order to get an eviction order. So, and most judges have been pretty good about checking for these, but before your landlord is allowed to have a hearing and ask the judge to grant an eviction, they need to have filed with the court an affidavit basically saying that you're not protected by the CARES Act. We do recommend that you do your own investigation and go on these websites and, check to make sure that you're not in some kind of public housing, and don't just rely on your landlord to do it. The affidavit is just a document basically with the landlord's signature at the end saying they're not covered. So we would hope that all landlords would be honest, but we do suggest that people do their own investigation as well. Lastly, executive orders. There was an executive order recently issued on August 8th, and there has been some confusion about exactly what it is and what it does. Its title was Executive Order on COVID-19 by providing assistance to renters and homeowners. What it actually does is it orders the secretaries and heads of department of various federal agencies and departments to consider what actions they might be able to take to help renters and homeowners avoid eviction or foreclosure. It does not, and the political dialogue and the public dialogue, in the news and on social media surrounding this executive order has been that it is some kind of an executive order issuing an eviction moratorium or preventing all evictions. That is not the case. It does what I just explained here. It does not in any way delay or prevent evictions that are pending in court right now. There is no current federal or state moratorium on evictions in Georgia. I want to be really clear about that. Except for situations covered under the CARES Act, evictions are proceeding in Georgia. Lastly, I just want to talk about some housing scams that we've encountered. Some are things that have been going on, before COVID-19, but have become more prevalent now. Some are a little newer, and we've seen more of now that COVID-19 has been an issue. First is scams connected to utilities. This is usually something that comes up when someone might be late on utility payments. We want to be clear that utility companies are not going to call you to ask for payment over the phone. They're not going to call you and ask you to give them your credit card number or whatever on the phone. If someone calls you and says they're your utility company, just let them know that you intend to pay online and contact the utility company using contact information from your utility bill. Or if you know what your utilities company's website is from that, do not contact the utility company via information that was given to you over the phone, because again, that could just be a scam number. And do not make payments over the phone. Next is, while you're searching for new housing, don't provide personal identifying information or financial information to somebody who claims that they're a landlord in order to reserve a property that's being advertised as for rent. If the person that is claiming they're going to rent to you says, we want to have your bank information so we can confirm that you can pay rent, those things are not things that a landlord should be asking for. They shouldn't be asking for a copy of the front and back of your credit card. They shouldn't be asking for bank information. They shouldn't be asking for any of that. If somebody does do that, please do not give them that information. Also, make sure you have a good physical address for your landlord before paying them any rent. Something else we've encountered is people claiming to have the right to rent a property, taking a security deposit, taking first and last month's rent, and then just vanishing. And then later on, the tenant finds out that actually they never had a right to be anywhere near that property at all. Please be careful about this. Make sure you have a physical address. If you don't have a physical address and they disappear with your money, you can't tell the police or a court where they are, and you probably lost your money and there's no way to get it back. So please be careful while you're searching for housing. We understand that it's very, very difficult to find housing in the current situation, but please don't let that have you take risks that you shouldn't be taking. While you're facing eviction, evictions are not a criminal matter. If someone calls you and says that if you don't pay rent, your landlord is about to file for a criminal warrant against you, or you're going to be arrested, or anything like that, do not believe them. You will never be arrested for not paying rent. Don't believe them. Don't give them financial information. Don't make a payment over the phone. That is not how evictions work. To talk a little bit more how evictions do work and how tenancies work in Georgia, in case you're in a situation where you're a tenant and you're facing eviction, I'm going to turn the presentation over to Kaleem, and he's going to take it from here.
All right, thank you, Elizabeth, for the information. It was very informative. As you've heard, my name is Kaleem Barclay. I'm an EPP attorney at the GLSP Augusta office, and I'm going to be talking to you about tenant rights and the dispossessory process. So starting off, we can look at the different types of tenancies in Georgia. They fall under two categories. You have your written lease agreements, and then you have your tenancies at will, also known as month-to-month tenancies. Now, generally in tenancies at will, there are no written lease agreements. and changes in rules require a 60-day notice from the landlord. Both types of tenancies are protected by Georgia law, so a landlord has to go through the dispossessory process and cannot use self-help methods to remove a tenant from the property. However, written leases have their advantages. They have the specific rules, guidelines, and length of the tenancy for all parties to understand and know ahead of time. Tenancies at will or month-to-month tenants are kind of different. They persist on a month-to-month basis, and a termination of this type of tenancy only requires that a landlord provide a 60-day notice for any reason. So if the landlord decides that they don't want to rent to you any longer and you are a tenant at will, they simply have to provide you with a 60-day notice. If they want to change a rule or increase the price, they only have to provide a 60-day notice. However, in a tenancy at will or month-to-month tenancy, a tenant only needs to provide a 30-day notice to allow the landlord to know that they are deciding to leave. So due to these rules, I often encourage individuals to consider a written lease agreement, as the advantages of a locked-in set of rules and pricings and length of tenancies has a significant advantages over the kind of vague and amorphous nature of a tenancy at will. Tenants want to be protected and want to have an understanding of the length of their tenancy, and if that's the case, it's always better to have a written lease agreement where everything is locked in and understood ahead of time. Now, moving to the next slide, we're going to discuss the eviction process. So landlords must first provide a tenant with demand for possession prior to filing an eviction. Again, landlords cannot engage in self-help remedies under the law. They have to engage in the dispossessory process. So first, they must provide demand for possession. Demand may be done orally or in writing. That 60-day notice I told you about for tenancies at will or month-to-month tenancies is not equivalent to demand. However, demand can be as simple as demanding that rent be paid or the person move if there's a payment issue. And demand can also be as simple as stating that at the end of a written lease agreement or when they're issuing their 60-day notice, they can say that they intend to sell or lease the property to someone else. After the landlord provides demand, the landlord has to go to the clerk of court and file what is called a dispossessory affidavit that is sworn out before the court. The affidavit will state the grounds for the eviction, how much, if any, is owed to the landlord for the tenant's failure to pay, what rules are broken, or the reasons that the tenant is going to be evicted. Moving on to the next slide, we have to understand that after the landlord files the dispossessory affidavit, they must serve the tenant. So service can be done in two ways, either personal service or tack and mail service. Under the personal service, a marshals or the sheriffs have to serve the tenant personally by hand. That means that the tenant will receive the dispossessory affidavit from a marshal's officer or a sheriff officer in hand at their door. If you receive a dispossessory affidavit in this manner, it is highly encouraged that you file an answer, because if you don't file an answer, you will get a default judgment, and if there are any money attached with that, then you may be liable for that money judgment as well. Tack and mail service is a little bit different. If the tenant cannot be served in person, they may be served by posting the notice to the door and mailing the summons on the same day to the last known address of the tenant. This happens when the marshals or the sheriffs can't find the individual. They knock on the door, nobody answers. They'll simply tack the notice onto the door, mail it same day, and it's effective service. The difference in this service is, in a tack and mail service, judgment for rent cannot be rendered upon a default judgment, but can be rendered if the tenant answers. So, if you do not answer a tack and mail service, and you understand that you owe a good amount of money and you can't pay and you have somewhere else to go, it may be strategically advantageous to you not to file an answer, as you won't be hit with a money judgment under tack and mail only if you do not file an answer. However, if you do not file an answer for personal service, you can still be hit with that money judgment. So we do request and encourage that people file an answer to personal service if they believe they have a solid defense and if they can dispute the claims in the dispossessory affidavit. Moving on to the next slide, we're going to talk about the answer. A tenant has 7 days from service to file an answer with the court. The information on when and where to file your answers is located on the dispossessory summons that you're going to receive from the marshal's office or the sheriff's office. An answer must deny, dispute, or challenge the claims of the landlord. So if an answer admits or fails to challenge the information in the dispossessory, then some courts may, but not all, may strike the answer and treat it as a default judgment, granting the landlord a writ of possession. We highly encourage everyone to file an answer if they would like to keep possession of their tenancy and they have some way of denying, disputing, or challenging the claims of the landlord. It could be as simple as the amount stated in the dispossessory affidavit is incorrect, or there are some overvailing repair issues that are affecting the tenancy. And answers should allege any counterclaims relevant to the tenancy. That means repair issues unaddressed by the landlord not abiding by the rules of the tenancy, or any other disputes with the landlord that has caused damage to the tenant's property. All should be alleged in your answer as counterclaims. All relevant counterclaims should be alleged, because if they are unalleged, it may be difficult to bring these up at a later date. So you want to allege them in this action so that they are heard by the judge, because again, they can be difficult, if not impossible, to allege later on. Now, moving on to the next slide. We want to encourage everyone to file their answers in person. And generally, the rule is your answer is filed in person. But because of COVID-19, we want tenants to contact the court to determine if the court is open and what safety procedures are in place. Remember, like Elizabeth said, always bring a mask and always bring whatever PPE is required by the courthouse. If an answer is not filed, the court will enter a default judgment as soon as the 8th day, and the landlord can receive a writ of possession. In personal service, if an answer is not filed and a money judgment is attached, then the money judgment can be rewarded. So you want to always file an answer, especially if you are served through personal service. But again, we encourage individuals to contact the courthouse to see what type of safety procedures they have in place, and we encourage you to file an answer in person. And one more thing, do not wait until the last day to file an answer. It's very important that you file your answer as soon as possible so that there are no delays and so that you can receive a hearing date. Moving on to the next slide. There are certain defenses available to tenants in Georgia. Georgia Code 44752 provides the tender defense to anybody served with a dispossessory affidavit for non-payment of rent. Now, this defense can only be used once in a 12-month period. That's important. So if a tenant pays all the rents due, the late fees, and the court costs of the dispossessory affidavit within 7 days after service, then the tenant has a complete defense to the dispossessory affidavit. This money is necessary and needed in that 7-day time period. If the landlord refuses properly offered tender, the tenant may make that answer state that they've provided the landlord with tender, and they are allowed to bring the money to court, and they are allowed to pay in the court registry. So be sure that if you're utilizing this defense, that you are going to state to the court that you are exercising the tender defense in your answer, especially if you are paying into the court registry. The court needs to know why this money is being paid and where is it going to. It is always best practice to state that you are filing your answer and exercising your tender defense. And for any organizations or any rental assistance organizations listening that work with tenants, the time period is very important. It is of the utmost importance that tenants have the funds in that 7-day answering time period. Otherwise, payment is outside of the law and is subject to the discretion of the court and the landlord. That means that they don't have to accept it after that. So it is always best that the tenant has that money in that 7-day answer time period to be within the confines of Georgia Code 44752. Moving on to the next slide. we have another defense available to tenants in Georgia. Georgia law provides another protection for tenants who face retaliation and dispossessory for seeking to exercise their rights for repairs in Georgia. So in Georgia, tenants have the right to request repairs to take action for securing those repairs. So if a landlord takes adverse action against a tenant for a tenant requesting repairs, for contacting any government entity or agency such as code enforcement, or participating in any tenant organization regarding the condition of the property within 3 months of the tenant doing any of those actions, if the tenant receives a dispossessory or termination of the lease based upon anything but non-payment of rent, then it is presumed that the landlord has enacted in some type of retaliatory act, and that is going to be presumed in court. It is the landlord's responsibility in court to rebut those claims, meaning they're going to have to show evidence that the action that they took to remove the tenant is not retaliation. If the court decides in favor of the tenant that the action was retaliation, then the tenant is entitled to some damages and compensation for the landlord's actions. Moving on to the next slide. We're going to discuss the hearing here a little bit. Tenants should know that the hearing is usually informal and moves fairly quickly. You can expect your hearing to last anywhere from 5 to 15 minutes. Tenants should be short, concise, and to the point about their issues so that the magistrate understands what has happened in their situation and why they should retain their tenancy. So if a tenant files an answer, a hearing will be scheduled by the court fairly quickly. That means in some courts, it could be the day after. And in the COVID era right now, in some other courts, based upon the backlog of cases they may have, it could be as far as 2 weeks away. But note that if you file a sufficient answer, you are likely to get a hearing, and the hearing will come quickly. If the court rules for the landlord, it will provide a writ of possession allowing the tenant and their property to be removed from the property. So going on to the next slide. So either party has 7 days to appeal the court's judgment. The writ of possession will not be executed until the appeal time expires. That means that after the court issues its judgment, if the tenant loses, the tenant has 7 days to file an appeal. Now, a tenant may want to file an appeal if they have the ability to pay and believe that the court did not properly address their issue. And also if there's a strong belief or basis that the dispossessory has been improper. If a tenant wants to keep possession of their property, the tenant needs to pay the court the amount the court found due plus the court costs for filing the appeal. If the tenant can't afford the court costs, they may request a pauper's affidavit from the clerk of court, and that will be provided to them, which will waive the fees for filing the appeal. However, if they want to keep possession, they still must pay the amount that the court found due. All right, so moving on. We'd like anybody who has any questions to contact Georgia Legal Services Program. We can answer your questions, provide advice, and if warranted, provide service for your case. You can contact us at 1-833-GLSP-LAW and 1-833-457-7529. And we'll open up the floor to a few questions.
Yes, and I just wanted to say, please do contact us if you have very, very specific questions about your exact situation. Please remember that when we're doing questions now, this is going to be, everyone can hear this. If you don't want to tell people your personal information or what you're exactly going through, please call us and open a case file and we can give you some one-on-one assistance. All right.
All right. If you have a question, please type it into chat. And I do want to clarify that Georgia Legal Services can represent tenants who meet our eligibility criteria, which is that they are a household with a low income, and we go by the federal poverty guideline, and in many cases can represent tenants who are below 200% of the poverty guideline, and we do have a citizenship requirement. for our services. If you are interested in or want to refer someone to us for assistance, that number is 1-833 GLSP Law. That is our intake number. We encourage you to refer people who have issues, or to call that number if you're a tenant and you need help. Okay, one of the questions we have is, how can tenants pay fees and rent if they have lost their jobs?
Yeah, so I mean, and this is a tough situation. Georgia law, basically, if someone has lost their job or is facing medical issues, or has lost a family member, just doesn't have the money to pay, Georgia law does provide, unfortunately, that those people can still be evicted. Again, we talked about the CARES Act that provides some limited protections due to COVID-19. I know that someone had a question about fees. Some fees, if the landlord is covered under the CARES Act and the fees were incurred between about March and June or July, those fees may be something that have to be waived. But if not, unfortunately, the landlord can still charge fees. Now, there are some times when a fee would be considered so kind of outrageous that a court would not allow a landlord to charge it. For example, if your landlord is charging you like double rent because you paid late, that I contact Georgia Legal Services if you're eligible, or if not, contact another attorney. That may be something that you can get the court to not allow your landlord to charge. But if it's something like a late fee of like $50, $100, unfortunately, that may be something that the landlord will be allowed to charge. But again, for a case specific, that may vary case by case. So contact an attorney for specific information about your situation.
Right, and to follow up on what Elizabeth said, there are some rental assistance agencies in every area in Georgia willing to provide funds. Different organizations have different fund limits. You can check these organizations by using various sites. One of those sites is rentalassistance.us/state/Georgia. You enter your zip code and it'll link you to various rental organizations in your area. Give those places a call, contact them if you think you're in trouble, and see what type of funds they have available. Provide them with the proper documentation after you set up an interview with them to prove that you are going through your financial hardship and that you are being evicted or facing the dispossessory process from the courts and your landlord.
Can you repeat that website again, please?
Yes, rental assistance.
You said the rental? Yes, the rental assistance.
Right, it is called rentalassistance.us/state/Georgia.
Thank you.
Colleen, if you can post that link, that would just in the chat, that would be great as well.
Okay.
Absolutely.
Oh, got it. All right, so someone else had a question. It's a little specific, but it's a question that comes up a lot. If someone has applied for rental assistance and the rental assistance agency says, yes, we'll pay, they contact the landlord, they say, we're prepared to pay, how can we pay, give us your information. The landlord says, I won't take money from you. Landlord is not allowed to do that if it's within 7 days of when the tenant was served. Basically, if a tenant is able to get the landlord the money that they owe, this is the full amount that they owe, including late fees if that's applicable and court costs, within 7 days of being served with an eviction case, that's called the tender defense, and that is going to be a defense to the eviction. So your landlord, if you had all the money ready, you would need to have proof that you had all the money. If it's your money, we suggest that you get the money in the form of a rental order, or a money order or something that has the date on it, and then bring that to court and show the court that you had the money and the landlord just wouldn't take it, and the court will basically order them to accept it and dismiss the eviction case. But if this is something where the rental assistance agency is still considering your application and hasn't made a decision yet, and your court date comes around, unfortunately, just the fact that you applied for assistance, that would not be a defense to the eviction under Georgia law.
I would just like to add too that it's important the eviction process moves quickly. Once a tenant is past due on the rent, the landlord need to only say pay or move, and then they can go that same day in most cases, those not covered by the CARES Act, and file for the eviction. And then once the action is filed and it's served, it's usually served. I mean, COVID has changed things, but in the past, evictions were served very soon after they were filed, and then that 7-day answer period begins to run. That 7-day answer period is when tenants need to make their tender. So if a tenant does not tender or file an answer, on the 8th day, the court will issue a writ of eviction. Now, if the tenant files an answer or tenders, and anytime a client tenders payment to the tenant, to the landlord, they still need to file an answer. So during the 7-day answer period, if a tenant tenders, they still need to answer. And if they don't answer, they'll go into default. But even if the tenant files an answer, while we are seeing delays between the time the answer is filed, the time the hearing is scheduled because of COVID, there are still courts, particularly courts that don't have a high volume of dispossessories, that will schedule the hearing on that dispossessory usually within 2 weeks. So if a tenant knows that they are headed towards the eviction process because they haven't paid their rent in several months, it's important that they reach out for legal and rental assistance early in the process and not wait until they're served with court papers. Because the rental assistance process takes time. And during the tender, what has to be offered is the payment, not a promise of payment. Thank you, Elizabeth, for letting me cut in.
No, that's fine. Thank you. All right. Let's see. If the so the tender defense is a defense to eviction for non-payment of rent, and I want to be clear about that. It's not a blanket defense to eviction for any reason. If your landlord is filed for eviction for non-payment and is also claiming there are other lease violations, you would need, you could use the tender defense, but you would also need defense to the other lease violations, and that could be very specific to case by case. So if that is a situation, I'd reach out to an attorney just to make sure that you have some defenses. Next question, I see someone asked about federal assistance programs for landlords. So as Georgia Legal Services, we do only represent tenants. However, I can definitely tell you that in some situations, if there's a mortgage that's backed by a federal mortgage backer, there are programs that you can reach out to provide mortgage assistance through the federal government. And I believe that some of those are like deferred payments. They'll do that and basically say you don't have to pay for the next 8 months, and then you can continue paying as usual. There are those programs available for homeowners. So also if you're a renter and your landlord says I have no choice, I can't pay my mortgage, I have to evict you, you can let them know that those programs do exist, and maybe that will help the situation.
Okay, so we have another question regarding when a tenant has to move out after a judgment has been entered against them. After the judgment has officially been entered and there is no appeal, after 7 days, the landlord will be provided a writ of possession. We do encourage people to move out within that 7-day time period. Every jurisdiction differs when it comes to when the landlord will exercise the writ of possession and when the marshal's or sheriff's office will schedule the set out. But we do encourage individuals to move out within 7 days after the judgment from the hearing.
Yeah, and often you can contact your local sheriff's office or the marshal's office and find out when oftentimes they'll schedule these ahead of time, and you can usually find out when they've scheduled it. And just to be clear, when the sheriffs show up with the writ of possession that the court has issued, that is the time that you would have to move out. I mean, you would have basically enough time. If you haven't moved anything out, you can grab whatever you can carry and move out, and the rest of it, unfortunately, in Georgia, can be put on the curb at that point, and your landlord does not have any legal responsibility if that gets stolen from the curb or if it gets rained on and ruined. At that point, they will have followed the law and they can't be held liable for those damages. So we do advise people, if it looks like you're going to be evicted, come up with a plan for protecting your belongings, if that's just moving them into storage, but you will need to be having a plan to protect those if that's the situation.
And another question we have is asking about, are there any situations where the court will accept a payment plan? That will involve mostly the tenant and the landlord and their relationship. If the relationship is cordial and the landlord seems to trust the tenant has the ability to pay, the parties can enter into something called a consent agreement, which will provide a payment plan if the consent agreement speaks to that payment plan. So the two parties can set up a payment plan, the consent agreement can be signed off by the judge, and the two parties can execute that consent agreement where the payment plan is abided by. And if not abided by, then the eviction process can continue if that consent agreement is violated. But again, any agreements are going to be determined by the relationship between the two parties and the trust between the two parties. And those agreements can be turned into a consent agreement, which can be signed off by a judge.
Yeah.
I would just like to, you're probably going to say this, Elizabeth, I just want to point out that anytime a tenant is working out an agreement with their landlord regarding partial payments or a payment plan, it's very important to get that agreement in writing.
Right. Always in writing, always signed by both parties and dated.
Yeah, and I mean, even if this is if this is you and your landlord before your court hearing and you're emailing back and forth or texting back and forth, if you exchange specific terms, and this isn't just, well, we'll work something out or we'll consider working something out, but this is, I agree to pay $200 on the 1st of the month and $500 on the 15th of the month, very specific terms, and so you send that and the landlord says, yes, I agree to that, and I won't proceed with the eviction. That can be evidence that a settlement agreement was entered into, but it does have to be in writing. If all you have is, well, I talked to them on the phone and they did say that to me, but you can't prove it any other way and the landlord says it didn't happen, that's not going to be good evidence. And just to talk about that process a little bit more, coming to a settlement agreement, that can happen before you go to court. A lot of courts, I would almost say most magistrate courts, will send both parties out into the hallway when it's time for their hearing and just say, well, you guys just talk and see if you can come to a resolution so that you can come up with something that you're both at least somewhat happy with before I come in and hear the case and make a ruling. And that is usually the time when those settlement agreements are put down in writing and signed by both parties. And then you go before the judge and the judge will usually approve a settlement agreement. One final note on those, they are not appealable. So if you sign an agreement and then you have second thoughts or you change your mind about what you're able to pay, you cannot file an appeal of that settlement agreement. It is final with the courts. If you put your signature to something, it can't be appealed. If the judge issues an order and the judge is the only one who signed that, that can be appealed, but not something that's a settlement agreement. So if you keep that in mind, you will have to follow the terms of that order. Make sure you understand what those terms are. Make sure that you understand if the settlement agreement says tenant will make these payments and will move out in 30 days, or if it says tenant will make these payments and if the tenant makes this payment will not have to move out in 30 days. If you don't read the order, you don't read the agreement clearly enough and you agreed to something that you really on second thought didn't want to agree to, it's too late at the time the judge signs that agreement. So just be very careful that you read through that and you understand what's in it. Okay, so I do see a couple of questions from landlords. Unfortunately, we really can't give advice on how to file an eviction against someone. I'd say contact a landlord's attorney, and they would be able to give you advice on that. We do have an office in Savannah. We have offices throughout Georgia. If you reach out to our website, that'll have the addresses of all our offices. We are working remotely, so your best option, I think, would be to contact our intake line and open a case, and they will make sure you get forwarded to the correct office, the correct region, and find someone who can assist you. If an agreement is reached, does that avoid eviction on the person's record? This is kind of a complicated question. If you reach a settlement agreement and a writ of possession, and part of that agreement is that a writ of possession will not issue, then there is not technically an eviction on your record. That wouldn't affect your credit. However, if a future landlord did a search for your name or called the magistrate court and asked them if you'd ever had an eviction filed against them, it would still show up that you had an eviction filed against you, but it would not show up that that eviction was granted. So that's, again, and that does depend on the terms of the agreement. If the agreement says that an eviction will issue in 14 days or 21 days instead of the 7 days that a court is permitted to grant you, then that would still show up as an eviction. How do you get an eviction removed or shortened? Colleen, do you want to take this one?
You mean from your record?
Yeah, the next question is removed from your record.
An eviction will not be removed from your record if it has been entered and the judgment has been entered officially. So if that writ of possession was issued and if there's a judgment against you, that eviction will be on your record. Yeah.
There's no similar procedure in civil court to an expungement in criminal court. It's unfortunately it's just there. Can non-attorneys advocate for their peers in magistrate court? No, you have to be very careful about this. Only an attorney can speak for a person in court on their behalf. That would, I mean, if someone else tries to speak for them, that would be considered unauthorized practice of law. Usually a judge will realize that this person isn't an attorney and will basically say, no, you cannot speak for this tenant. You can speak as a witness on their behalf, but you cannot act as their advocate in court.
To answer the question about the time period before a marshal or sheriff tries to provide personal service versus tack and mail service, if they knock on the door, you're not answering, it could be within minutes because they have a lot of these to do and a lot of other duties to attend to. Then it could be as simple as you not coming to the door and then tack and mail is issued. Again, with tack and mail, you should definitely be able to be notified that you have received this because it will be on your door and it will be in your mailbox. We encourage people to, check their tenancies out, especially if they know they're going through some problems with their landlord and they know they've received demand for possession before, to always check their door and to check their mailbox just in case.
And you can also call the clerk of magistrate court. If your landlord is talking like he's filed an eviction against you, but you haven't gotten anything, check with that because we have occasionally, you might have an unscrupulous landlord or just some kind of mistake that happens and the notice will not be on the door like it should be. And we advise you to just check with the magistrate court clerk because if service wasn't done correctly and you don't show up to court or you don't file an answer, the judge isn't going to know that service wasn't done correctly. And once that eviction order is put in place, it's very, very difficult to undo something that's been done in that way. So please check if you think something might have been filed, but you just haven't received anything. Because if it turns out it has, you want to be able to file an answer within 7 days of when it was supposedly served. And you can say in that answer, I wasn't served correctly, but you do need to file an answer. Okay, so going back, we're a little behind on the questions, but someone's asking, what's the time frame for it to stay on your record? Unfortunately, it is on your record. there is no, it's not like driver's licenses where after a certain period of time it's required to be erased. It's on your record. Sometimes, if, for example, this is a courthouse who does things online, they might try to clear off some space and try to remove that after a period of years, but there's no guarantee that that's going to happen. We have some repeat questions.
I have a question on abandonment.
Okay.
Yeah, I can take that one. So if your tenancy has ended, let's say you are a tenant at will or a month-to-month tenant and your landlord has provided you with that 60-day notice, one note, you do still have to pay money throughout that 60 days. But at the end of that 60 days, if you are moving out and getting everything out, your landlord can't claim abandonment. Same with your written tenancy ending. If your lease term is over with and you are moving out on that final day, again, your landlord can't claim abandonment. If you have a dispossessory filed against you and you are moving out based upon your landlord stating that they provided you that 60-day notice, or that your tenancy has ended under the lease terms, then you have an actionable defense in court to state that I was moving out, my lease term is over, there is no longer a landlord-tenant relationship. And that lack of landlord-tenant relationship will be able to be proven in court by either the 60-day notice or by proving with your written contract that the lease term is over. Otherwise, if you had some type of agreement, move-out agreement with your landlord, again, like we encouraged earlier, you are encouraged, highly encouraged, to get that filed and signed, by both parties. So make sure both parties have signed it, make sure both parties have dated it, and make sure both parties have a copy of any type of move-out agreement between the parties ending the tenancy early.
I would also like to add that abandonment is very, I don't know what happened to our screen.
I think, could everyone make sure that they've got mute on if you're not a presenter? Sorry.
Yeah.
If you're a participant, please mute yourself. And if you would like to turn off your video, you can as well. This is recorded, so just keep that in mind.
We had a question about abandonment that Kaleem addressed, but I would also point out that while we're not giving advice to landlords, I would add that it's always safest for a landlord, if he has a question about whether or not a property is considered abandoned, the safest way to go is to file a dispossessory and get the court order authorizing the removal of the tenant and the tenant's property. Because then there can be no question about the landlord's liability for removing the property. It may appear to a landlord that the property has been abandoned and the tenant has given up possession, but there's a risk involved in going in and removing the property without that court order allowing you to, because a tenant can always turn around and say, I hadn't abandoned the property, I had, the utilities were disconnected, were still connected, I had paid rent, and that was an illegal eviction. And so it's just always safer for landlords to go through the eviction process.
Right,
Yeah.
and to add on to that, if you are moving out without contacting your landlord before your lease term is up, you are still responsible for the remainder of the lease term, and the landlord may file a dispossessory against you. One should be careful if they are moving out and should make sure that the agreement is understood by both parties and signed for.
Yes, and when we talked about tack and mail service, if a tenant has left a property, the landlord can file a dispossessory. There won't be personal service because no one's living there, so it'll be tack and mail service, which means it will be stuck in the door and sent in the mail. Now, if a tenant has left the property, they're not going to get the tacked copy. That's why it's so important that when a tenant leaves a property, that they put in a change of address with the post office so that if the mailed copy will be forwarded to them. Otherwise, if there's no change of address, the post office will deliver the mailed copy to the address of the residence and the tenant will never receive it. So it's important to put that change of address in.
And that's also just a last follow-up. That's also important for security deposits. If your landlord doesn't know how to find you or how to give you back your security deposit, after a period of time, they are permitted under the law to keep that security deposit. So that, again, is another reason why you want to leave a forwarding address. If you sign a lease but changed your mind or can't afford to move because you lost your job due to COVID-19. Okay, so if you signed a lease, that is going to be something that is kind of case by case specific. It's hard to give general advice because that can cover a broad range of situations. I don't know, if it may be different if you've moved in, if you just signed it. What the provisions of that lease are will play a big role in what I as an attorney would advise you to do. I would suggest talking with your landlord and seeing what they are willing to agree to or not agree to, and then going from there. And I would suggest contacting an attorney for specific information. If you've not moved in yet, it's going to depend what the lease says. If the lease allow you to terminate early, are there penalties? And to be able to speak with the landlord about that as well. It will depend case by case.
Yes, most written leases do have early termination penalty. So, and when you sign the lease, that is when the tenancy begins. Even if you do not move into the property, you've signed that legal contract. So those lease termination penalties would apply. However, it is possible if something's happened and you need to get out of a lease to engage in a discussion and negotiation with your landlord to allow you to terminate the lease early and to waive those penalties, those early termination penalties contained within the lease. However, if the parties reach such agreement, once again, vitally important that the agreement is in writing and that it state not just that the tenant is allowed to move early, but that those penalties under the lease for moving early are waived, and the tenant, won't have to pay them. And then to address also the security deposit issue. In most cases, if there's an early termination, the security deposit is forfeited under the terms of the lease. So yeah, just get those things in writing.
Okay, someone's asking, with power of attorney, can you go to court for someone? Susan, can you take that one as well?
Yes, you can. In magistrate court, you can. And the power of attorney, read it carefully and make sure that it covers the dispossessory situation. But yes, you should be able to go into magistrate court and represent that person.
And we have one more that you may need to address, Susan.
Okay.
Regarding advocacy for change.
We at the Georgia Legal Services are prohibited by our funder, the Legal Services Corporation, from participating in any lobbying activity that would influence how any government agency, the action of a government agency. We can not take a position on pending legislation. However, we have, when requested by the legislature and specific representatives, been able to provide information on the problems we see or the impact of certain laws on our client population. But no, we cannot do that. If I'm going to make a last call for questions before we end today.
Yeah, I've been scrolling through. I think we've answered pretty much everything. If we missed you, please repost. I'll hold out for a little while longer.
Okay. All right. So I want to thank everyone who attended today. My name is Susan Reith, and I am the Housing Unit Director for the Georgia Legal Services Program, and also the Director of the Eviction Prevention Project of Georgia Legal Services, which means I am privileged to be able to work closely with Elizabeth and Kaleem, who both see, as everyone can see, has done a wonderful job today. And I appreciate their assistance. If this will be recorded, we will send out a link to where we post it, so you'll have access to the information. And thank you to my wonderful presenters, Kaleem Barkley and Elizabeth Main. Thank you, and thank you to everyone who attended. We had great attendance today, and we really appreciate it. And remember, refer people to us at Georgia Legal Services. Our intake number is 1833 GLSP Law.
And you can find us online as well, glsp.org.
Yes. Thank you, Elizabeth. All right. Everyone have a great rest of the day and a wonderful weekend.
Colleen, can you hit end?